Did cold calling motivated sellers just become illegal? It is January 27th, which means it is D-Day for marketing, apparently for wholesaling real estate. FCC, the TCPA, all these new rules have just dropped, apparently, that is going to change everything in wholesaling real estate. What is going on? Because I have heard a million things, and I'm here to set the record straight. It has been known for about a year that today the FCC has dropped their one-to-one consent rule, which affects massively internet leads. Now, not really for the wholesaling part, but kind of to a point too. So we really have to break down exactly what's going on. Now, I'm recording this the morning of the 27th because a lot has happened in the past 48 hours with this law. And the thing is, I've been hearing more and more from people that, oh, Zach, you don't know, it got canceled. The law got canceled. It's not going to happen anymore. And I'm like, well, I read the law and it's not being canceled. Who are you hearing this from? And you guys are hearing bad information. And every single time somebody says they heard or they thought or somebody said, it's all hearsay. And so like a game of telephone. What I'm going to do is just show you the brand new updated law as of today so you can understand it. And so really quick, it's suspended. It is not canceled. It is still going to happen. The appeals court did take it off and did suspend it, but there are some things that we should understand when it comes to this. So let's kind of read exactly the order. This was on Friday, but basically the order is postponing this TCPA one-to-one consent rule by 12 months to January 26th, 2026, or until the date specified in the public notice following a decision from the court's review. Very important to understand that this rule, if the judge decides or the Supreme Court decides, no, this is real, it's going to happen within 10 days. This is insanity to me. And so a lot of people are just kind of not understanding that, like, hey, if a date is chosen on a public notice that the court has overturned the overturning, boom, this thing is actually going to be a real law, like effective immediately. So it's really important to understand what this FCC one-to-one consent rule is, how this affects wholesaling, and answer the most important question. Is wholesaling legal when it comes to cold calling? Is it legal for me to cold call motivated sellers? What is the FCC's rules on calling? Can I call a DNC list? Can I text them? Because as of today, I'm going to show you what's legal now, what's going to be legal in the future, and all these things. But the biggest question is, can you cold call, and is it legal for you to cold call the DNC list? What's this new FCC law? I know I have plenty of wholesalers who watch this that are doing internet leads. So internet leads are going to be PPC, SEO, PPL, Facebook ads, all these different things, right? It's like how this one-to-one consent rule massively affects those, and it creates more liability, but also has a slight effect on texting when it comes to DNC and all these things. And so what I did actually was last week, I recorded an entire video on the TCPA one-to-one consent rule. Now, what I'm going to do is share with you exactly that video recording, because it does break down, the first half of it breaks down what this law is, because the Supreme Court or any other appeals court can at any point decide not to take the IMC's case, and boom, now it becomes a law. So we should know about it if it instantly happens. Second, we got to understand this, that the Insurance Marketing Coalition is the big one that is doing the big fight here, because they sell leads and this really hurts them. So they're doing a big, constitutional battle fight, whatever you want to call it here, about robocalls and all these things. And there's really not many crazy definitions of this. And so what I'm going to do is share that video recording. It's going to be edited a little bit because it's not like officially enacted, but it's definitely going to change a lot of stuff. And what you got to understand is the Supreme Court can pick this up. It is set to be enacted in a year, but courts are going to change it. So we got to understand this. But the second half of the recording that I'm about to show you is me breaking down exactly how TCPA law works, how the FCC has defined wholesaling to a point, and is it legal for us to cold call? We're going to save that to the end because that's the most exciting question. The most important part you got to understand about this and what I'm going to show you is I'm going to show you evidence. I'm not going to show you what I think, my interpretation of the law, because I'm not a lawyer. And every lawyer is going to say, I've had lawyers say it's illegal and it's not illegal. And the cool part is I'm just going to show you what judges have actually done. And so I'm going to give you a shocking statement, but wholesalers have actually been sued for calling a seller without a real estate license, offering to buy their house. And we actually have judges' decisions showing, does that constitute marketing or not? Did they deserve to get a fine for breaking DNC law, or are they exempt? Now, I've already told you, us wholesalers are exempt from all DNC laws when it comes to seeing if they're interested in selling the property. The one kicker here is if you're a realtor, then you get in some hot water, which we're going to share exactly how that works today. So this is going to be the recording. Remember, the law is now not officially enacted. It has been suspended, but it can, basically, if you read this, it can happen at any time based on this new appeals, and it might go to the Supreme Court, who knows. So just understanding that a lot of stuff can happen. It's not enacted now, but the DNC law and TCP laws are still legal right now. So we're going to break down exactly if cold calling is still legal and what we can do about this. Guys, let's break it all down. Like usual, I don't tell you what the information is. I don't tell you what I think the law is. What I like to do is to show you the law. Like, actually, let's read it man to man, man to woman, whatever, right? Let's actually read the law together so we both can read it, because I feel like you're a smart person or smart enough to be able to read words that are the law. And this is not vague laws at all. It's very, very specific. And what I want to do is just tell you what's going on. Why is it all legal today? How this affects cold calling, how this affects SMS and every type of other wholesaling marketing, and really what this means for wholesaling going forward. Now, spoiler alert, I have everything popped up, and I mean, there's going to be some big changes happening for a lot of different wholesalers, but let's break it all down. So basically, in December 2023, there was something called the one-to-one consent rule that kind of got adopted. And the reason for this new law and change isn't to go after wholesaling real estate specifically. The reason of this law was to go after these robo-callers, these robo-texters, the FCC deemed. And the point of it was they wanted to end what they called the lead generator loophole. And what the lead generator loophole was if you were interested in getting an auto warranty, if you were interested in comparing shopping results, or if you put something in the internet of being interested in getting a mortgage, what those lead providers would do is they would sell that lead to 7, 8, 9, 10, 1,000 different providers. And this was the same case for wholesaling real estate. There are specific companies called PPL companies that provide leads. They might call, they might do a pay-per-click campaign, they might do some SEO, Facebook ads. And what they used to do was they would sell you the lead for $300, $400. They used to not tell you this, but they used to sell it 2, 3, 4, 5 times, make $2,000 from one lead. Why not? But other PPL providers did not do this, but they were put in that category because, unfortunately, why I don't like PPL is a person will put in Google, sell my property fast, Houston, and they won't click on the first PPC ad. They'll click on all 4 PPC ads of Joe buys houses, Emily buys houses, Zach buys houses, and Rick buys houses. They'll put a form in to get a cash offer from all of them. Unbeknownst, all 4 of those we buy houses are all PPL providers. And so that same lead goes to 4 different PPL companies. They're all being sold for $400 or $500 each. And yes, the PPL provider had that lead, but that lead also put their information on 4 or 5 different websites. So it wasn't the PPL providers selling it multiple times if they were like a good and legitimate one. It was just they put in their information way too many times on all these other providers. And so that's generally why PPL is not the best. From the people that do deals on PPL, they have told me between 1 out of 25 and 1 out of 30. And to combat this, a lot of PPL companies have decided that they're not going to sell you leads for $400 each, right? They're going to sell you the lead for $40, but they're going to let 10 or 12 people buy that lead. And they're actually, I give it to them, some of these providers are actually transparent. They're like, hey, we sold this lead 12 times. Do you want to be the 13th guy? It's only $40. Now, what was set to happen was this is going to close that loophole, basically meaning that if you are generating leads and you go and sell that lead, you are considered a lead reseller or a lead generator, right? The person that you generate the lead of, right? This motivated seller, for example, you would have to get prior written consent from that seller that, hey, I'm going to sell this lead to this person or give this lead over to them. And you can only do it to one person. You can't sell a lead to multiple people. Now, there are some loopholes some PPL companies are doing in wholesaling, which actually are pretty smart, but it's looking to prohibit what they call lead generators. And so what this basically means, if you're a PPL provider, if you're running Facebook ads or anything like this, you cannot resell that data multiple times. Now, there's actually some very clear exceptions. So if you ever go to Wholesaling.com, you figure out how I cold call, you talk about the DNC, we talk about TCPA a lot. Most of your wholesaling is actually going to be completely exempt from this rule. Let me tell you exactly what is part of it and what is not. So right here is the consumer guide of the one-to-one consent rule. This is basically a really quick FAQ, basically talking about the new laws and the new rules, right? It's to stop unwanted illegal telemarketing. It stops the lead generator loophole to attack customers multiple times. The specific example they're using are like comparison shopping websites. So what's the cost of flights from this company or this company, and then they sell that multiple times, right? I completely actually get it. And they're stopping robocalls or robo-texts, which us wholesalers don't do. Now it says here, under the commission's new one-to-one consent rule, which takes effect January 27, 2025 today, a prior express written consent requirement applies to single seller at a time. In other words, robocallers and robo-texters must obtain a consumer's, so the consumer is the person they're marketing to, written consent from marketing messages for each seller. So every single time they sell the lead, they have to get consent for each one. So for example, on a comparison shopping website, the consumer must check separate box for each seller they wish to receive a robocall or robo-text from, which us wholesalers, we don't do that. Now they explain why they're doing it. Now they made a very clear exception to this, that the new one-to-one consent rule does not affect the practice of connecting a third-party agent to a prospective customer on a telemarketing call that is not auto-dialed and does not include a pre-recorded or artificial voice message. Indeed, the new one-to-one consent rule has no bearing on such calls. So us in wholesaling, theoretically, if I was a PPL company, right, and I cold call somebody and they say they're interested in selling, and I connect them to the wholesaler, and somehow that wholesaler instantly paid me, which there are, I guess, you can get a wallet or something, that is legal. Now, the funny part about this is this law, if you are generating the leads yourself, you are exempt from this. Clearly, connecting to a third-party agent, which is hilarious. Like, I mean, there's no agent involved. You're just literally calling it yourself. You're not reselling the data. There's no prior written consent here. You're pretty much good to go. If a PPL company can do it, you can do it too. Same thing with texting here. Now, it's very important to know that TCPA still applies to all these calls. So you have to still follow what is considered the DNC list, which I'll show you exactly why us wholesalers don't have to worry about it. But as long as you're not using an artificial or pre-recorded voice, you're pretty much good to go. Now, again, this is my disclosure. Seek an attorney before you do anything, and always follow the laws of the land. And whatever I say is solely my opinion and not legal advice. Now, this is big on of AI, artificial intelligence calling and texting. So if it's actually not a real person calling, this is very, very big for those type of people, which I've been saying forever. Do not do these AI calling, right? Also, this here, the commissioner's do not call rules are also protect consumers from unwanted telephone solicitations or telemarketing calls when the consumer has added their number to the DNC registry. If a consumer's telephone number is listed in the DNC registry, the consumer can provide prior express written consent to receive telemarketing calls from the particular seller. Now, the very, very interesting part about this is a PPL company, a lead sourcing company, whatever you want to call it, right? They are selling a service. They're generating the lead and then selling that lead to you, the wholesaler. So they cannot call on the DNC list. So they can only call non-DNC numbers, which are like 70, 80% of them are on the DNC list. Us wholesalers, we are not telemarketing. You hear the word telemarketing, do not call the DNC list if you are telemarketing, telephone solicitations or telemarketing, right? Us wholesalers are exempt from that law if you are not a realtor. We'll go into that a little further. The FCC actually showed us exactly what that means here. But this is a cool FAQ. Now, what I wanted to show you is the actual FCC full report and order for the one-to-one consent rule. So here it is. It is the targeting and eliminating unlawful text messages and eliminating unlawful robocalls. Now, this is actually a great thing for the industry. It's stopping those AI calling. It's basically made AI calling illegal. I've been telling everyone, do not do it. It's kind of dumb. But really what we have to do is, guys, you can read all this information. Like, there's a ton of it here. And it explains why they're doing it, how they're doing it, all these things. But clearly, if you just really want to understand if you and wholesaling are legal and good to go and this law doesn't affect you if you follow the stuff we teach at freewholesaling.com. Let me show you number 8 here. So this is page 4 automatically here. It says right here, Telephone Consumer Protections Act and National Do Not Call Registry. The TCPA and the Commission's implementing rules require callers to obtain consumer consent for certain calls and text sent using an automatic telephone dialing system, or an auto dialer, or made using a pre-recorded or artificial voice. If a robocall or robotext includes or introduces an advertisement or constitutes telemarketing, the prior express consent must be in writing, including internet to phone text messages that are sent via internet to a provider that is routed to a consumer's phone over the provider's wireless address, are also covered in TCPA. The Commission's DNC rules protect consumers from unwanted telephone solicitations or telemarketing calls to wireless and wireless phone numbers in the DNC. Now, if you scroll to subsection 18 right here on the header, this is the really important part. So it's basically saying here again, you have to get prior written consent if you're doing telemarketing. Now, what's the definition of telemarketing? This is when everyone says, oh, wholesaling, you're screwed, you're done, you're going to get sued. It drives me crazy. Guys, look at this right here. Subsection 18 right here. The TCPA defines telephone solicitation as the initiation of a telephone call or message for the purpose of encouraging the purchase or rental of, investment in, property, goods, or services, which is transmitted to any person, but does not include calls or text messages made with prior written express invitation or permission. So really understand this. You're exempt from the DNC list as long as you are not encouraging the purchase, the rental of, the investment, or for you to basically sell a good or a service or property. So let me make this clear again. If you are not trying to sell a property, a good, or a service, you are exempt. Now let's play a little game. If you are a realtor, if I said that right for you, realtors, you are selling a service if you are looking to see if they're looking to sell their property. Because if they are, you can then offer to list their property for a commission, which is a service. You are providing a service. If I call you asking if you're looking to get car detailing and I can detail your car, that is a service. If I'm asking if you want to go buy my property, I'm actually looking to sell you my house. Illegal. If I'm looking to sell you a car, or if I'm encouraging you to sell a car to me because I have a commission service, illegal. If I'm trying to sell you something, I try to sell you this pen, Jordan Belfort style, that is illegal. I'm selling you a good and or a service. Now you might be like, well, actually, wholesaling is technically a service because you're doing an assignment of contract. Well, we actually have something in the United States called case law. Now, this is a very, very small definition, right? It's like 2 sentences of the DNC. What happens in the United States is, well, somebody sues somebody and says, well, actually, you're wholesaling the deal, and because of that, you are violating DNC. Now, people can sue you for anything. I've seen people try to sue people because they know, yeah, it's legal for them to call, but it's just not right. And a judge is going to judge based on what's right, not what's on the law. Well, we actually have case law, and what case law is, which shows the judge is judging the law and seeing if this applies in the situation or not. Now, the most famous case that I've taught, which is really the only one I've seen in wholesaling yet, is Josh M. Jantz plaintiff versus Home Run Offer LLC and defendants. This is in the United States District Court of Arizona in July 29th, 2021. Now, if you want to get a really quick summary, just to really understand this, it says in Jantz versus Home Run Offer, the court held that calls to the plaintiff's cell phone seeking to determine his interest in selling his house and not to induce a purchase by the plaintiff were neither telemarketing nor solicitation. So there's actually a summary from a very similar case just like this, but basically the judge said, yes, you calling somebody, seeing if they're interested in selling their house, and you're not inducing a purchase by the plaintiff, so you're not trying to get them to buy something from you, that's pretty much telemarketing 101. You're calling trying to take money from them. When you're calling and trying to give them money, which is us in wholesaling or us in just real estate investing or double closing, we're trying to actually buy their house. We're determining if they have any interest in selling their home. That is exempt from the TCPA. Go read all these numbers, read it, tell me I'm an idiot, but like this is true. This is actual case law. Now, we can get on the whole exact thing. Now, this person sued. They got it dismissed, right, which is awesome. But basically shows that, yeah, someone can always initiate a lawsuit about you. Anyone, if anyone. If you're watching this and you live in Georgia, I can sue you. I can sue you for anything. I could say that you were mean to me. Zach Ginn could sue you for defamation if you said a mean comment to me. Am I going to win the defamation case against you? Probably not, because there's not enough grounds for that. It's kind of stupid. But I legally could try to sue you just to be a jerk, and lawyers are always going to want your money. Same thing happens here. So they try to sue this person, and they got the case dismissed because they didn't violate TCPA. I think this is very, very clear here. So everyone says that, oh, you can't call DNC. Well, it's clearly shown right here. Now you might make the other case, well, what if I text a cash buyer seeing if he's looking to buy my deal? Well, we have some other case law here. This is Gross versus GG Homes Incorporated. So the summary of this, if you want to get the whole information here, in Gross, the court found that text messages sent to the plaintiff real estate agents by the defendant, which inquired about off-market deals or pocket listings, were not an attempt to solicit the purchase of a service from the defendant. It does not fall within the definition of the telephone solicitation under TCPA. So again, to make this very, very clear, this is clearly shown in wholesaling. You do not have a service. You are just trying to get their interest, see if they're looking for off-market deals or pocket listings. You are not selling a service in wholesaling real estate or double closing, right? We have plenty of case law showing that we're legal and we're good to go. Now, going back here to the FCC laws, one really important part here is the person that purchases the lead from, let's say, a PPL company is liable under this new law, which means if you buy a lead from a PPL provider, you can get sued. Yes, that's right. You are now liable in part of that lawsuit. And what has to happen is in the lawsuit, which you can get sued for anything, you have to show that the PPL provider did all of the prerequisites required to stay compliant. And if the PPL company was not good and compliant, you are going to get sued and you're going to lose the lawsuit, and the PPL company is going to lose the lawsuit. Now, I am not a fan of PPL companies, but there are certain ones, I'm not going to name them, that I am going to give some credit for. There are certain wholesalers that I'm actually friends with that actually got sued because they called the PPL lead that they bought. And the PPL company did cover the legal expenses for that lawsuit and they got it dismissed. So I do want to give some PPL companies, not all of them do it, but it's not that I hate PPL in general. I just think there's a lot better options, and the increasing price of PPL is just way too much. It used to be way cheaper. Now it's almost $400 or $500 a lead. It's going to keep going up because of bidding on PPC. But overall, that is the new one-to-one consent rule. PPL buyers now have extra liability. The PPL companies have to be a lot more stringent. Costs are going to increase on PPL over the board is my guess. And like always, if you're calling, texting, door knocking, reverse drawing for dollars, all the strategy we teach at freeholding.com. And as long as you're not a realtor, you're exempt from the law. You got to remember, there are case laws of wholesalers doing the interest. Are you looking to sell your property or interested? And they were a realtor. They actually lost lawsuits because they theoretically were a realtor, so they could have provided a service. If you are not licensed and you are not a licensed real estate agent, you couldn't even legally provide a service to sell the property. So you're actually exempt from the law. So this is why it's very clear, do not get a real estate license if you're looking to wholesale houses correctly, and stay within cold calling and texting TCPA laws. So like always, guys, this is all the information. If you got any value from this video, do me a favor, make sure you smash the like button, subscribe, go to freeholding.com, my free community and course. We'll see you soon. This is Zach signing out. Have a blessed one.